and fellow colleagues. This afternoon, we're going to have a presentation on the legal and regulatory aspects of corporate governance. And our learning objectives, by the end of this lesson, we are expected to understand the implementation of corporate governance principles in the context of the Ghanaian securities market, collective responsibility to minor corporate governance, review of the Ghanaian regulatory framework, the rights of shareholders, the equitable treatment of shareholders, disclosure and transparency. We'll look at the responsibilities of the board, code of best practices on corporate governance, the whistleblowing and corporate governance, and then we'll look at the Whistleblower Protection Act 2006. So, by way of introduction, in this chapter relies on the corporate governance guidance on best practices by the Securities and Exchange Commission of Ghana to explain the degree to which the legal and regulatory framework prevalent in Ghana's Ghanaian facilities facilitates the recognition of the underlying principles of corporate governance. So the regulatory framework for corporate governance, insofar as the securities markets are concerned, is contained in the Companies Code of 2019, Act 992, the Securities Industry Law 1993, that's the PNDC Law 333, and the Membership and Listing Regulations of the Ghana Stock Exchange. So this framework is supplemented by international financial reporting standards and the principles and codes of professional conduct imposed by the Institution of Chartered Accountants Ghana on its current championing the development of National Corporate Governance Code, which is likely to take effect, which actually was supposed to take effect last year. I don't know whether because of COVID that thing took place. Now, implementation of the corporate governance principles in the context of the Ghanaian securities market. The Securities Industry Law 1993, PNDC Law 333, invests the Securities Regulatory Commission of Ghana with the function of creating an atmosphere for orderly growth and development of the capital market and protecting the integrity of the market. So, considering the significant contribution that good corporate governance can make to the achievement of the above objective, the Commission has considered it appropriate to formulate and enunciate its position on the matter. So the Commission has also considered it appropriate to issue guidance notes on the manner in which, taking into consideration the state of development of the market in Ghana, the regulatory framework, and the domestic corporate culture and circumstance could be implemented in the Ghanaian context. So in doing so, the Commission has also been cognizant of the fact that the shaping of an effective regulatory framework must be balanced by the need for sufficient flexibility to allow markets to function effectively and to respond to expectations of shareholders. So by so doing, the Commission is confident that maybe though the adherence of good corporate governance practices will help improve the confidence of investors and thereby ultimately reduce the cost of capital by inducing more stable sources of finances. So if Ghana is to reap the full benefit of global investment, its corporate governance arrangements must be credible, well understood, and have universal acceptance. So, in circumstances, it is the intention of the Commission that all listed corporate bodies and companies licensed by it should endeavor to adopt as much as possible or practically feasible mechanisms which will ensure the implementation of appropriate corporate governance practices in their management and operations. So it is also necessary for corporate bodies, especially those that are listed, to regularly disclose their degree of competence, a degree of compliance with acceptable corporate governance practices in the public manner. So now, yes, let's look at the collective responsibilities to monitor corporate governance. The commission, in other words, envisages the ensuring of proper corporate governance practices as a collective responsibility that is cast upon the persons involved in the operations of the corporate body. So one of such group is the board of directors. And in this, I'll say that there are three important groupings of persons whose cooperation the commission considers integral to achieving acceptable corporate governance practice. And that includes the board of directors and managers of the corporate body, as well as its shareholders and other stakeholders. So now we look at the board of directors. They have a number of responsibilities, and they are required to fulfill certain key functions, which include reviewing and guiding corporate strategy, major plans of action, risk policies, annual budgets, and business plans, setting performance objectives, monitoring implementation, and others, and overseeing major capital expenditure, acquisition, divestiture. They are also supposed to assist in selecting, compensating, monitoring, and when necessary, replacing key executives and overseeing succession plan. They also responsible for curtailing the misuse of corporate assets and abuse in related party transactions. Again, ensuring the integrity of the corporation's accounting and financial reporting systems is also part of the responsibilities of the board of directors. Reviewing key executive and monitoring and managing potential conflicts of interest among management, board members, and shareholders. They're also responsible for ensuring compliance with the law, overseeing the process of disclosure and communication, ensuring the monitoring and management of risk, and then reviewing key executive and board remunerations, and ensuring a formal and transparent board nomination processes. These are all part of the responsibilities of the board of directors. Now they are supposed to be seen as independent. So now we look at the independence of the board from management. So in order for boards to effectively fulfill their responsibilities, they must have some degree of independence from management. So board independence usually requires that sufficient number of board members should not be employed by the company or be closely related to the company or its management through significant relations, i.e., economic or family or other ties. It does not matter. This does not mean that though shareholders and other people may be discouraged from being board members, they can also be board members. However, it does not also imply that maybe a balance must be maintained between controlling the shareholders and managers and other persons with ownership or proprietary interest of the company. Again, independent or non-executive board members can contribute significantly to the decision-making process of the board by bringing an objective view to bear on the evaluation of the performance of the board and management in particular. Next, board of company, the board of companies are encouraged to also consider appointing a sufficient number of non-executive board members capable of exercising independent judgment to tax where there is potential for conflict of interest and other things. So independent board members play an important role in areas where the interest of management and shareholders diverge, such as the executive remunerations. Now we can look at the role of the chairman of the board. So the chairman, as the head of the board, can play a central role in ensuring the effective governance of the corporate body and functioning of the board. So the separation of the roles of the chairman and the chief executive is therefore very important, and it's a good mechanism to ensure that appropriate balance of power is maintained, and that will also ensure the independence of the board. And this is actually advocated as a mechanism of ensuring an appropriate balance of power, increasing accountability, and enhancing the capacity of the board for independent decision making. Now, directors, looking at the general responsibilities of directors, we say that directors should devote sufficient time to their responsibilities. Service on too many boards can interfere with the performance of board members. So it is also very important that companies consider whether excessive board service interferes with board performance, and this should be a fact taken into account at the time of nominating even the board members or directors. It is necessary to emphasize the need to ensure that members of the board enjoy legitimacy and confidence in the eyes of shareholders as regards their commitment to discharge the functions and obligations imposed on them. Now, training. In order to improve board practices and performance of its members, it is useful for corporate bodies to engage in orienting new inductees to the board with the activities of the company and the law under which it operates. This is of paramount importance, especially in circumstances in which the directors can be held personally liable for breaching the law. So, continuing education in order to remain abreast of relevant new laws, regulations, and changing commercial risk is also recommended. Access to information. And to fulfill their responsibilities and to support decision making, board members should have access to accurate and relevant information on a timely basis. Shareholders and stakeholders must also have the right to influence the corporate body on certain fundamental issues, such as one, the election of board members, two, changes in capital, three, amendments to the regulations of the company, four, approval of extraordinary sanctions, and others.
Transactions. Approval of extraordinary transactions.
Approval of extraordinary transactions,
Yeah.
and so on. That's the responsibility of the directors,
No, shareholders.
shareholders, and
That's
stakeholders.
the yes.
Yes, sir. So we look at the auditors. The financial and annual reports are increasingly becoming the most extensive use, the most extensively used methods for the conveyance and dissemination of corporate information to shareholder and investors. So these reports are a medium for disclosing not only the financial status of a company and its performance, but also information pertaining to ownership, governance, business ethics, and in some instances, the public policy commitments. So the Commission recognizes that the quality of this information depends on the standards under which it is complied and disclosed. Auditors play an important role in ensuring the quality control of financial information that is disseminated. And the independence of auditors and other accountability and their accountability to shareholders is crucial to the governance of a corporate body. So now, looking at the review of the Ghanaian regulatory framework, first we look at the rights of the shareholders. The Companies Act 2019 and the Securities Industries Law 1993 and the regulation of the Ghana Stock Exchange provides some primary regulatory framework for establishing and operations of companies that issues publicly under trade securities. So the basic shareholder rights includes the right to secure methods of ownership registration. And these laws and regulations provide the basic shareholder the rights that he or she deserves. The second one is the right to convey or transfer shares, the right to obtain relevant information on the corporation on a timely and regular basis, the right to participate and vote in general shareholder meetings. They also have the right to elect members of the board and share in the profits of the corporation. So shareholders also have the right to participate in and to be sufficiently informed on decisions concerning fundamental corporate changes such as amendments to the statutes or articles of incorporation or similar governing documents of the company. You also have the right to obtaining decisions concerning fundamental corporate changes in the authorization of additional shares, again in variation of class rights and extraordinary transactions that in effect result in the scale of the company. The rights of the shareholder, continuing looking at the equitable treatment of shareholder. We know that the laws referred to, that is all those laws that we looked at during Abigail's presentation. Those laws recognize the principle of equitable treatment of all shareholders. So no distinction is made between foreign and domestic shareholder as regards shareholder rights under the law, except that foreign holders in listed companies are subject to ownership thresholds based on exchange control restrictions. Minority shareholders are afforded the opportunity of obtaining effective redress for violation of their rights under the company's code, and all shareholders issued and all shares issued unless otherwise specified rank pari passu, that is satisfied with other shares of the same class in issue. And in the case of ordinary shares, one share carries one vote. So the securities industry law prohibits and penalizes inside trading and abusive self-dealings. So now we look at the role of stakeholders in corporate governance. So stakeholders' rights are established and protected under the general laws pertaining to commerce, contracts, and labor. Disclosure and transparency. The Companies Code 2019 mandates the laying of annual audit accounts of a company before its shareholders in general meeting. So the code specifies the minimum content of such accounts and also the qualifications of auditors competent to report on such accounts. So the listing regulation of the Ghana Stock Exchange provides the time frame within which annual reports of listed companies must be circulated. So the standards adopted and issued by the Institute of Chartered Accountants Ghana provide for the quality of presentation financial information must conform to. So that quality is also governed by the ICAG. The listing regulation also requires investors to be provided with information of a price-sensitive nature, including the information on issues that materially affect the financial and operating results of the company, and others. That includes the material issues regarding employees and other stakeholders, and some may be foreseeable risk factors. The company's code also requires directors to disclose any material interests in transactions or contracts affecting the company. And these ones too, there are channels that have been listed for dissemination of information to the stock exchange and then others. So now we look at the responsibilities of the board. The Companies Code 2019 specifies the basic responsibilities of the board of a company. It also makes provisions for the appointment, retirement, removal of directors, and also with regards to other qualifications. It requires all listed companies to establish and maintain audit committees. And that is very clear in all the companies code as well as the regulations of the Ghana Stock Exchange. So the commission, now the code of best practices and corporate governance by the Securities Regulatory Commission of Ghana. We say that the Securities Regulatory Commission, with a view to providing some guidance on mechanisms which will contribute to the implementation of a suitable corporate governance practice in corporate bodies licensed under the Securities Industries Law and the users of publicly traded securities, particularly those listed on stock exchanges, approved under law, has formulated the following body of best practices. And these best practices are based on principles enunciated by the Organization for Economic Cooperation and Development and Commonwealth Association of Corporate Governance and codes of corporate governance issued by regulatory authorities in emerging markets. So the practices embodied in this document do not have the force of law. They are primarily intended to be guidelines whereby the standards of governance in corporate bodies regulated by the Commission may be benchmarked. The best practices are evolutionary in nature and should be adapted by users to suit their own particular circumstances, provided the spirit of the principle underlying the practice is maintained. So the code of the best practices will apply to all corporate bodies approved or licensed. So now we look at the code of best practices on corporate governance by the Regulatory Commission.
Securities
First,
Regulatory Commission, yeah.
yes. First is the section 1, which is the mission, responsibilities, and accountability of the board of directors. The section 2, and in this section, it talks about principles and objectives, talks about the primary responsibility of the corporate governance, the duties of the board, the size of the board, appointment, orientation, training, multiple board seats, separation between chairman and managing director or CEO, talks about the chairman, composition, appointment, qualification, non-executive members, and so on. Even the financial director, terms and age limits, access to information, board committee meetings, the company secretary. So all those ones are listed in this session. So when you look at the session 1, right from where it talks about the mission, the responsibilities, and all those people, their responsibilities and duties are all enumerated in that one. And the session 2, which talks about the committees of the board, that is the committee in general. It talks about most of the committees, i.e., the audit committee, their composition, their function, and where they derive their authority from, their reports that needs to be submitted, the remunerations, functions of the remuneration committee, reporting committee. So all the various committees that you can think of in the corporate body, it's really spelled out in this section 2 of the Code of Best Practices on Corporate Governance by the Securities Regulation Commission of Ghana. The section 3 looks at the relationship to shareholders and stakeholders. So this relationship is also elaborated into details, looking at the shareholder, the shareholders, and the stakeholders. the communication policy between the body and then the shareholders and stakeholders, quality of information communicated, the information and non-financial affairs, meeting of members, and so on. Then the section 4 now looks at the financial affairs and auditing financial governance of the body. And with this one, looking at all the standards that we are looking at, the financial reporting, ensuring that you go by the financial reporting standards, international financial reporting standards. We look at the disclosure of price sensitive information, role of the external auditor, the duties of the auditor, audit report, departures and deviations from standards, rotation of audit personnel, removal or resignation of an auditor, and all those ones. They are also captured in this one. And then the section 5, which is the disclosures in annual reports, looks at the chairman's statement and the statement of responsibility of the financial statements, statements as to the degree of compliance with the law, as to the degree of compliance with corporate governance practices, statements as to the enterprise being a going concern, that it will not actually collapse in the short term, and other matters to be disclosed. So all these ones are also captured in the disclosures in section 5. And then section 6, which is the code of ethics. And I think we dealt with ethics in our earlier presentations, which also talks about the requirements of a code of ethic, responsibility for formulation, monitoring, adherence, matters pertaining to the development of code of ethics, and others. So now we can now look at the whistleblowing and then the corporate governance. The role of the whistleblowing in corporate governance needs to be expanded. And without reporting wrongdoings, I mean, corporate governance is lacking. So it inspires trust in the stakeholders and serves as a warning indicator for any impending threats to the organization's existence. Many industrialized nations, including the USA and the United Kingdom, have passed aggressive legislations to guarantee and encourage whistleblowing mechanisms through the adoption of strict rules. And this is because the strong and reliable corporate entities upon which the economic dominance of such nations is based. And that is why theirs is very strong. Here, sometimes when you do it, you tend to be afraid for your own life. But there, they have the laws backing the whistleblower. So these nations' citizens' job and post-employment prospects depends on reliable enterprise. So these businesses are represented in various parts of the world. So both Enron and the Maxwell saga are two well-known instances of whistleblowing. And then for Aaron's own, he raised accounting concerns 5 months before the company's collapse. And in that one, it was he was really upheld for his good job and then the concern that he raised. Now we look at the whistleblowing itself. What is whistleblowing? That is the first thing that we would ask ourselves. That's expressing worry about a wrongdoing without a company or through a separate organization connected to it. So whistleblowing is described as an action taken by a person who feels that the public's interest comes before those of the organization